Welcome to the Appellate Division First Department. We have 6.5 hours of argument time requested. Therefore, only ask for the time that you need, not the time that you want. We are familiar with your briefs, we're familiar with the record, and if we need more time, we will keep asking questions. People versus Perea. Appellant? Submitted. Cassiano versus City of New York. Appellant? And how much time are you requesting? 5? And do you want any rebuttal time? 5 and 1 and 5. T City is submitted. Sabrell versus Svet. Appellant?
6.
Respondent? 6 and 1 and 6. Janet Transit versus Mott Haven. Appellant?
Good morning, good afternoon, Your Honor. Appellate 10 and 5 for rebuttal.
Is respondent here?
I do not see respondent in the courtroom.
Do you want to submit then?
Suppose. It's been happening before. I guess I don't call them then. I submit it. The respondent is not present.
Okay, it's submitted.
May I consult with my... Can we have a second call? Is there a second call?
No, I'll give you 3 minutes though, okay?
Okay. Thank you, Your Honor.
People versus Ortiz. Appellant?
On behalf of appellant, in light of respondent's concession letter, we'd be happy to submit unless the panel has any questions.
We do not have any questions.
Thank you.
And it is submitted. CMB Export versus Motcom Estates. There are 3 appeals. They're all going to be argued together as one appeal. So the time will be to argue all 3. Appellant?
25 minutes, Your Honor.
Respondent?
25 minutes, Your Honor.
7, 2, and 7. And again, if we have more questions, we'll keep asking. People versus Rodesco is submitted. Endino versus Wizard Studios. Appellant? KM? And how much time are you requesting? 5 minutes. Okay, I see 4 people, but there should only be 3, right? Who you? Andino. Did you have an appeal?
Yes.
And how much time are you requesting?
5 and 1, Your Honor. Respondent cross appellants, Wizard Studios, AT&T Mobility Solutions, and Mosaic. 5 minutes, please.
And your plaintiff?
I'm responding to the City of New York.
And how much time are you requesting?
1 minute.
And the plaintiff is not here. Oh, Andino is the plaintiff. I'm sorry, that's where I was confused. I was the city I wasn't expecting. You didn't put any papers in.
I put in response.
Okay.
Did you not get it?
I think I'm just confused. Okay. 5-1, 5-1, 5-1, and 1. Marte versus Tishman.
Appellants, 5 minutes and 1 rebuttal, Your Honor. For respondents, appellants, 5 and 1, Your Honor, please.
Is there a cross appeal in that case? 5-1 and 5-1. Merrick versus Maserich Company. Are you Tyson? I'm sorry, 5?
5 and 2.
Respondent Maserich, Your Honor, 1 minute.
I'm sorry, who are you representing?
The Maserich entities.
And you're asking for 1 minute? Okay. And is the plaintiff here? No. Okay. 5, 2, and 1. People versus Tolbert, appellant.
Appellant, and Colbert, request 7 and 2, Your Honor. Respondent, request 5.
6, 1, and 5. Diaz versus New York City Health and Hospitals. I'll give you 3 minutes, and if we have more questions, we'll ask. People versus Unger, appellant?
Respondent requests 10 minutes, Your Honor.
6, 1, and 6. People versus Collier, appellant? Submitted. Parada versus Heron is submitted, and Price Waterhouse versus Cahill is submitted. So our first case today will be Cassiano versus City of New York.
Good afternoon, Your Honors. Janet Navarro with Seekus Law Group, representing the plaintiff appellant Juan Cassiano. And we're here today because we believe the lower court erred in finding that the affirmative negligence exception to the prior notice statutes was not applicable in this case. We believe that where the lower court went wrong is because in the complaint it did contain sufficient allegations, and that the facts are also there that created a triable issue.
Let me ask you, why should we accept the expert's opinion when it's undisputed that the expert didn't actually go and investigate the location until many years after the accident occurred?
Well, the expert, it's true, I agree. He did not go there until after the accident.
Years after the accident.
Years after the accident, but courts have held that that's not an impediment to allowing expert testimony. In fact, it's pretty common. But he was basing his expert opinion upon the testimony of the city's own employee, Adam Ware. He was also basing it on the city's own document, the Bollard installation form, which clearly and irrefutably shows that the city of New York did install this device that caused my client to trip and become injured. It's really irrefutable evidence. I do think that the trial court, I think mostly what they see are these prior notice problems. This was not that case, and I think that the court and the city did spend a majority of their time on that.
So, Counselor, the date of the accident was December 8th of 2016.
Correct.
There's photographs, there's Google Maps and evidence that were submitted by the city for 2017 and 2021 with respect to the existence of the bollards as is in 2017 and an apparent cure by 2021. Do these photographs help you or hurt you, and to what extent, what bearing do they have on your affirmative negligence argument?
The photographs that were taken after the accident, I would argue, are not relevant in the sense that we're arguing that they were immediately dangerous upon their installation.
Well, in that context, they were installed August of 2016, and this
Correct.
accident occurred in December, just a mere 6 months later.
Right.
And based on this record, the condition of the bollard holder and the location and its proximity to the crosswalk, pretty much with the exception of that very first bollard, it pretty much remains the same, right? There's no real argument there. The way it was installed is the way it is now, more or less.
Correct, Your Honor.
Which puts it right into the cause and created exception to the prior written notice rule, right?
I agree. Yes, it does.
I mean, you see these bollards all over the city. What is the standard, and how is it to be determined as to where these bollards should be located vis-a-vis the crosswalk?
Well, the city, Mr. Adam Ward testified that he doesn't, that the city of New York does not take that into consideration when they're installing. They're not concerned about pedestrians, and he did testify to that. So they don't take that into consideration, and we argue that they should have.
Didn't the city expert acknowledge that it's a potential tripping hazard?
I believe so, yes. I believe it's common sense it's a potential tripping hazard. It's a 3 to 4 inch device in the roadway, basically in the crosswalk.
You also assert, I think in the bill of particulars, that the bollard got scuffed and at night you couldn't see it because of the scuffing. Wouldn't that be something which is not caused and created by the city, but something which develops over time, just as a pothole might develop, and isn't to rely on that aspect of the insufficiency or the negligence in putting up the bollard, wouldn't that be something which would need prior written notice? In other words, for you to rely on the scuffing of the bollard, wouldn't that be something which the city would be entitled to prior written notice?
I agree with the honor, and I agree that would be a private notice problem. It was an alternative argument. That's not what's being appealed today. It was the fact that it was immediately dangerous upon installation.
Because it was so close to the crosswalk.
Correct.
That's your primary argument.
Correct. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Friedman, and I'm appearing for the defendant respondent, City of New York.
A reversal?
Go ahead.
A reversal here would mean that there's an issue of fact, is there not, whether this was negligently installed?
Well, Your Honor, if the court reverses the order granting summary judgment, then yes, then the court
That
could.
would mean you'd have to have a trial on whether it was installed in the right spot.
Well, Your Honor, actually, the fact is here that there is absolutely no evidence that this particular device was immediately dangerous upon installation.
Well, if it was immediately installed too close to the crosswalk, making it unsafe, wouldn't that be something that the city created and was instantaneous?
Not in this case, Your Honor, because basically the linchpin of plaintiff's argument is that Nicholas Bellizzi, their expert, said that it was installed too close to the crosswalk and that it caused, basically, you didn't leave enough latitude and trucks and cars coming around could actually hit the bollard. But there are two problems with that supposition
Well,
here.
it's not really about the trucks hitting it or not hitting it. It's about it being in the way of plaintiff walking on the crosswalk. But go ahead.
Well, Your Honor, we're talking about an exception to the prior written notice requirement. And certainly the plaintiff didn't meet his burden of showing that this is an exception to the prior written notice requirement.
If you were to find that the city created this condition, then you wouldn't need prior written notice. Isn't that true?
As an exception to the prior written notice rule, that is correct.
So why isn't this an exception?
Because two things for that. There is certainly no evidence showing, Mr. Bellizzi opined, he made this opinion in his affidavit, there's no evidence, there's no empirical data, there's no studies connecting the particular placement of the bollard to an immediately dangerous condition. So simply saying so doesn't make it so. It's a
But the
conclusory.
plaintiff is saying, look, it was too close to the crosswalk, and therefore in the dark and with traffic and all that, it was placed so that if you got out of the crosswalk a little bit, you're going to trip. And the city didn't consider that in installing the bollard.
Well, Your Honor, the basis of Mr. Bellizzi's opinion is that basically it was because traffic could run over the bollard and cause it to be not visible and
I don't
collapse.
think that, I didn't take that to be his main theory or the main theory why this bollard was dangerous, because traffic could run over it. I thought it's because specifically it was close to the crosswalk so that a pedestrian could come into contact with it when crossing, and that it was supposed to prevent traffic from turning a certain way, but it wasn't really meant to be in a place where a plaintiff could potentially come into contact with.
Well, I think what he was saying basically in his affidavit, page 842 of the record, he's saying it caused large wheel-based vehicles making left turns to run over the quick curb traffic control device at the easterly end and caused high visibility, reflective, and conspicuous vertical marker to be missing, creating an unsafe and dangerous condition. But
Wasn't that only one of the bases of his theory, though, as to why it was dangerous?
well, it's certainly what he's saying why the installation was dangerous.
Didn't he also separately state, and that's what we talked about with opposing counsel, that it was also dangerous because of where the exact location in which it was placed, that it should have been placed further back?
But for those reasons that he went on to explain, because there was no color contrast, the bollard was missing, I think that's the basis of
So
his
you're saying
opinion.
that it's inextricably intertwined, we can't separate one argument from the
Well,
other?
well, Your Honor, in this case, as the Supreme Court found, Mr. Bellizzi didn't know what this looked like in 2016.
But is that really the main issue that's in front of us? Isn't the issue that we have to address, did the city create this condition so that you're not entitled to prior written notice of this condition? Whether or not its placement was correct that would be an issue for trial. But if you created it, you weren't entitled to prior written notice, and therefore there shouldn't have been summary judgment in your favor below.
Well, Your Honor, without knowing what this particular device looked like in 2016.
Let's go back to that, because if it was improperly placed too close to the crosswalk, that would be immediately apparent as soon as it was installed, and it wouldn't change over time. It's sort of not a transient condition. It's a condition that's permanent, if that theory is accepted. So what difference would it make when it was actually examined by the expert? Because nothing would change in terms of its location being close to the crosswalk, whether it was examined a day after or 5 years after.
Well, the problem, Your Honor, is that although he cited to the manual, the quick curb manual, there is no proof or no evidence of anything to show that it was in fact placed too close to the crosswalk. And
Thank
he
you.
simply can't make that assertion without submitting any evidence, data, studies, authority, nothing to
Thank you.
support that. And I'd also like
No,
to point...
your time's up.
Yes, thank you, Your Honor. And the notice of claim did not provide, and the complaint did not provide for this theory of liability. Thank you very much.
Unless the court has any questions, I'll happy to waive the minute.
Any questions? Okay, thank you.
Thank you.
Sabrell versus Smith. You may be seated, yes.
Good afternoon, Your Honors. May it please the Court, my name's Jonathan Pollack, Beldock, Levine, and Hoffman, LLP, for the appellant Maurice Svet. Your Honors, appellant relies on the principle that a party is not entitled to be credited against amounts due under a judgment of divorce, either one, for voluntary payments made for the benefit of his or her child.
Below, didn't you take the position that contractually the appellant was required to pay a portion of the college tuition, and what you asked for below was that the court should modify the agreement to, instead of having the 57-43 split, that the respondent should be responsible for 100% of the tuition. Wasn't that your position below?
The Court's correct on that, yes. Yes, that was the position.
In other words,
below.
under the contract, the parties had agreed that the husband was going to pay the father was going to pay 57% and the mother was going to pay 43% of the tuition.
Your Honor, I don't, that may have come from the below, but it's not in the agreement.
That was in the affirmation. That was your argument below.
Yep.
And you asked for the court to modify the contract to provide, to modify the stipulation to provide otherwise.
That was certainly in error, as is revealed on the appeal. There is no obligation on the appellant to pay any part of the college.
So just so
It
I
just states the
understand, your
57%.
argument now is that the wife did not have any obligation to pay for any amount of the college tuition, that the husband was obligated to pay for 56%. Who would pay for the remainder based on your interpretation of the agreement if the wife wasn't required to?
Yes, that the agreement was made because the wife really didn't know whether she could afford to pay the 43%
So
at the
what
given
was
time.
your understanding based on your interpretation of the agreement of who would pay for the remainder of the college tuition?
No, that the father certainly voluntarily did, and that was
Right,
part of
but
the argument.
obviously it
below,
wasn't
the
his
voluntary.
obligation to do so, so
No.
whose obligation was it to pay the remainder then?
Yeah, I don't think it was anyone's obligation.
So why did you ask the court to modify the agreement? I mean, to change it that the father should be responsible for 100%, that obviously presupposes that the mother was responsible for 43%.
Well, yes, it was
That
also
your
argued.
position below that under the stipulation, the mother was responsible for 43%, right?
You know, I don't remember it as well as Your Honor, but I
Well,
think
mean,
Your Honor
have
is
it
correct.
in front of me,
Yes.
so I see that what you asked for was a modification
Yeah.
to provide for the father to be responsible for 100%.
Are you changing your position, counsel? I need a clarification because I'm a little confused.
Yeah, well, we're retaining part of the argument, which was that the father's not entitled to a credit for voluntary payments, which he certainly made, and that was made below, that it was a voluntary payment by the father. And even the court below said, you're not entitled to be credited for voluntary
And you're
payments.
saying it was a
And the McKay says
voluntary,
also. Sorry?
you're saying it was a voluntary payment because neither parent was obliged to pay for the child's tuition, period?
Yes, yes, and that's the
You're
argument being
obviously
made.
not saying that because that doesn't make any sense because the husband was clearly obligated to pay for a portion.
57%, yes, yes, he was
You're saying
obligated.
no one was obligated to repay the remainder. Let me ask you, were there any?
That's correct,
Were there any
yes. I
questions
misunderstood, I'm sorry.
raised below or any discussion elicited below about any conversations between the parties as to the husband paying more than his percentage allocated in the agreement?
No, the record below was very sparse on conversations between the parties, although they kept each other apprised on a regular basis and they discussed the daughter's progress. That was the extent of the proof below as to the conversation.
I just want to be clear about this point.
Yes.
Was your position below that pursuant to the stipulation, the father was responsible for 57% and the mother was responsible for 43%? You then said, well, the mother really can't afford it and the court should change what the agreement requires. But the agreement required the mother to pay 43%.
Honestly, it was a very complicated situation. That was a mistake.
Well, that's a
yes.
yes or no question.
Yes,
Well,
yes.
Okay.
Yes.
I know
Yes to-
my
yes to what?
my colleague-
Yes, that was what was argued
My
below.
colleague is focusing.
I'd like to
what-
change my argument,
What
yes.
is your argument now?
My-
What is the argument you are now presenting to this court about how we should interpret
The argument, thank you. The
Because
argument,
I'm not really hearing that.
the argument now is that pursuant to Article 3, Paragraph 2, it says that the father is obligated for 57%. It says nothing about the mother's obligation. Therefore, she's not. It was a voluntary payment by the father, and under the McKay-Grosbeck case, voluntary payments,
Then
whether
let me
they're
go
for
back to
college.
my original question,
Yep.
which I don't know that I really heard an answer to. If the husband's obligated to pay for his portion, who is obligated under the agreement to pay for the remainder? And how can we decide this as a matter of law based on the language of the agreement?
Yeah,
Since it's silent as to who pays
it was
the
silent.
remainder. So how can we decide what it means just looking at the agreement?
Yeah, I believe that it means that there was a gap and that it would be filled by voluntary payment by one or the other.
Okay, thank you. Do you have another question before we go on?
Isn't the way the agreement is set up, it doesn't mention the mother specifically, but it's setting forth what the husband is responsible. It's dealing with the husband's obligations. All of the provisions at page 305, 306 of the record, they're dealing with what the husband's obligations are, and it's not discussing what the mother's obligations are. And as you previously recognized, the contemplation of the parties under this agreement was that the mother was responsible for the rest. I understand that now you're taking a different position, but that wasn't your position before.
Correct.
Am I correct in what I
Yes.
said?
Yes, you are correct. Your Honor.
Just one final point. There's no other provision in this agreement that discusses the mother's obligation to pay any percentage of the tuition. As my colleague pointed out, this particular section addresses the husband's or the father's obligation. There's no other provision anywhere else. It's utterly silent about the mother paying anything for tuition, correct?
For tuition, yes.
Which pretty much supports your position now in court.
I believe so, yes, Your Honor.
Thank you. Let's hear from
Thank you.
the Vice Counsel.
Good afternoon, Your Honors. Samantha Rosigno of the Pappalardo Law Group on behalf of the plaintiff respondent, and may it please the court. As for the college tuition expenses, in addition to everything that was just said by the panel, although the defendant is correct that the agreement does not explicitly state that the defendant is responsible for 43%, the college expense obligation of the plaintiff was enumerated in a list of 3 other additional add-on expenses, 2 of which are mandatory add-on expenses.
Let me ask
under
you
the
something, though.
CSSA.
Aren't college expenses inherently different than other expenses? I mean, it's clear that if a child has medical expenses, the medical expenses have to be paid for 100% by the parent. If the child has appropriate add-ons for therapy or anything during the childhood, that the parents somehow or another are going to have to fund that. But isn't college inherently different in that there is no requirement that they fund their child's education? I mean, it's good that they fund it, but there's no obligation. So if we're confronted with an agreement that's silent as to the wife's obligation to fund a percentage, how do we read that into the agreement where it's not explicitly there?
Thank you, Your Honor. And I agree with you. College expenses are traditionally treated differently than other mandatory add-on expenses such as unreimbursed medical.
There's no requirement that the parents
Correct.
pay them. The child could take out loans, the child could get
Absolutely.
scholarships. There's all different ways that college could be paid for. There's no mandatory requirement that parents pay for their children's college, although it's lovely if they do.
Absolutely. We're not in disagreement with that. However, in this specific contract, there was, if the court should turn to the record at 77, a list of 3 expenses for which it is silent on all 3 of them as to the defendant's obligation. Within this list are 2 others that are mandatory expenses. So therefore, it would unequivocally be assumed that the intention of the parties was that the defendant was going to pay for the remainder.
Why would it be where it's silent? Why would it be unequivocally assumed? Where are we getting to that?
So it's our position that none of the 3 listed the 43%. So since A and B are mandatory and the defendant does have the obligation to pay for A and B, that the same should follow for C. Otherwise,
let's say we find it's ambiguous. Let's just say we can't glean from the 4 corners what it's meant, then what would be the appropriate thing for the court to do?
Your Honor, it's our position that it should be treated, they should all be treated the same, otherwise they should have.
Is your argument that however we come out, we should decide it based on the 4 corners of the agreement and that no hearing is necessary to take additional testimony, that either way, we should decide it based on the language that's there, and if we accept your argument, we rule in the husband's favor, and if we don't accept your argument, we rule in the wife's favor?
Correct. If you're asking that all 3 should be treated the same because they're in the same list, yes, that is our position.
That's your position, obviously.
That's our position, yes.
So, counsel, I'm looking at the 3 items in the record on page 77, and it's all at 57%, but there's a little twist in one of them. So with 2A, it goes to 57% of the child's unreimbursed medical expenses. With B, it's 57% of the child's reasonable childcare expenses, and then it talks about the occupancy of if the wife and all of that part. And then with C, 57% of the costs associated with the college education. And there's nothing here whatsoever that references the mother's obligation, to the extent that such exists. So has the mother contested, or is there anything in the record that illuminates us as to whether the 43% was picked up with respect to medical expenses or picked up by the mother with respect to reasonable childcare expenses? Is there any point of comparison for us?
You mean outside of the 4 corners of the agreement?
In the record.
In the record?
Is there anything that shows that she actually did pay 43% of A and B, even though it didn't say anything specific?
So I don't know about 43%, but yes, she did fund the child's unreimbursed medical expenses and failed to request any contribution from the plaintiff, which was a separate issue on the lower court that is not here before you on appeal. But yes, she did contribute to those other expenses, and therefore, I think because they're involved in the same list, they should all be treated the same.
What is the effect of below the mother asked for the agreement to be modified to provide for the father to pay 100%?
Thank you, Your Honor. So defendant fails to cite any case law which would entitle them to a reformation of the contract here. In fact, the First Department has ruled, and I quote, "A contract cannot be reformed to include a
Why are we
provision."
talking about reformation? I thought we were talking about how the contract should be interpreted in the first instance. Reformation is not the argument that's before us on appeal. The appeal is how to interpret the agreement in the first instance.
I believe one of the...
Obviously, if the wife is obligated to pay those college tuition, then the husband gets an offset, and if she's not obligated, the husband doesn't. I'm not sure where, at least as the issues before us, reformation is in play.
I believe that one of the issues.
It's not a matter of reformation, isn't it a matter of what?
Can she
it's
answer
ob- Yeah. go ahead.
the question? Then you can
Answer Judge Kern's.
Okay. Excuse me. I believe it was my understanding that one of the reliefs sought by the defendant was reformation of the contract on multiple levels.
On appeal?
Yes.
But isn't the fact that she asked for modification below indicative of the fact that she understood the contract is requiring her to pay 43%?
Yes, Your Honor. Do I have to wrap up? I'm sorry.
Thank you.
Thank you.
Just to answer the one question about the record below did show that she paid 100% of these expenses, and in most instances was not reimbursed for any of it.
Okay, thank you.
Thank you.
Transit versus Mott Haven. I understand that both counsel are now here, and I will give each side 3 minutes based on the circumstances.
I'm sorry?
I'm going to give each side 3 minutes based on the circumstances of what occurred.
I appreciate the courtesy.
Good afternoon, Your Honors. Ricardo Oquendo of Oquendo Duraco and Luis A. Gonzalez of counsel to the firm for the appellants this afternoon. May it please the court. Although this appeal presents multiple issues for the court to consider on appeal, I would like to focus on one issue in the 3 minutes that I have. The trial court committed error by applying an incorrect legal standard to its determination on denying the preliminary injunction. Trial court below held that the applicable standard in deciding a preliminary injunction is clear and convincing evidence. That is contrary to...
Well, let's say it's likelihood of success on the merits. What likelihood of success on the merits is there with respect to the argument about the forbearance agreement, where the forbearance agreement expressly says there's no oral modification allowed? It has to be in a writing signed by the party to be charged. And there's absolutely no evidence in the record, concrete evidence, that Dime ever really entered into further negotiations granting this further forbearance. There's no writing, there's no email. So under those circumstances, where's the likelihood of success on the merits?
Your Honor, that question is addressed by Court of Appeals case Rose v. Spa Realty, which first established the principle that any non-modification clause in a written agreement may be orally modified,
Right, but you
and that
need some
becomes a question of
concrete
fact.
evidence. It's not always a question of fact. There has to be something in the record to support the oral modification. What is there in this record?
In the record,
Concretely.
we have not conducted discovery, which is why we sought the preliminary injunction to have an opportunity to perform discovery to be able to prove our oral modification. This was a series of oral modifications that were reduced into writing, 3 before the 4th, all of which were oral agreements that were subsequently, many months after they went into effect, were then reduced to writing. All of this occurred during the pandemic. So we argued that Rose v. Spa allows a party discovery to be able to have an opportunity to prove the oral agreement. There isn't going to be any written evidence in the record to prove an oral agreement. That is a subject of a question of fact. And we are now, only last Friday, the parties first exchanged discovery. Only last Friday. And in the interim, the respondent already has $6 million in judgments entered and are seeking to foreclose on those judgments, and we only started discovery last week.
Okay, let me hear from opposing counsel.
Good afternoon, Your Honors. Karina Straub of Hinshaw Culbertson on behalf of Respondent. May it please the Court. As to Your Honor's questions, we believe that Rose does not give any opportunity for a preliminary injunction at this point. Rose just speaks to the opportunity to pursue a potential claim. It very specifically states that if the only proof of an alleged agreement to deviate from a written contract is the oral exchanges, then the writing controls.
The original confession of judgments that were entered were all vacated because one of the parties isn't there anymore because of the transfer, correct?
Yes,
So there's no imminent danger
there
in
is.
enforcing judgments right now.
There's actually a second set of judgments that were entered because we were able to get an order that amended the caption. Those are a series of other disputes in other matters that were filed.
Let me restate it. At this point in time, while counsel makes a point of saying that they could foreclose on the medallions and on the real property as they claim was the scheme here between Dime and Mott Haven, arguendo, nothing is done right now, correct? There's no basis right now to show irreparable harm that would be one of the prongs for the preliminary injunction, correct?
No, and we are actually stayed based on an order of Judge Alpert that was entered recently. That's post-briefing, so that is something that we just argued yesterday, actually. So there is a preliminary stay in place while he considers appellant's application to vacate his order that amended the caption that permitted us to proceed with the refiling of the confessions. But there's nothing that's actually been done. We've not located any assets. We've not taken any assets.
Well, you know what the assets are. You don't have to locate them. No dispute what the assets are.
Certain of them. There's medallions, but then there's the judgment exceeds the value of the medallions. So there are
There's
certain.
also real property. Isn't that what the real?
The real property is separate. We haven't taken any action with regard to foreclosure of the real property. Appellants actually proactively filed this before there was any action taken on the real property.
So counsel, to the extent that the payment deferrals were based on the pandemic, and the first payment was then due on March 5th of 2021, how should we read the fact that the first request for a default was made in May of 2021, 2 months after the due date?
So there was a transfer that occurred in the meantime. Dime Bank, who was the owner on March 5th, sold it to my client on March 31st. The final documents related to the sale were executed early in mid-May. So there were some documents executed, but we didn't have everything until mid-May. So we were not in a position to truly send those letters out without all of our T's crossed and I's dotted until that May date came around.
Thank you.
Thank you.
CMB Export versus Markham Estates.
Good afternoon, Your Honors. Matt Parrott from Fried Frank for appellants Montcomb, Rubin Brothers, and CDCF. We're here today, Your Honors, seeking reversal of the motion court's denial of our motion to dismiss, our renewal on the motion to dismiss, the decision granting a preliminary injunction, and denying our request for renewal on the preliminary injunction. The court below accepted the plaintiff CMB's allegation that it was misled with respect to a loan upsizing that occurred in September 2020 because a participation agreement for the senior mezzanine loan at issue was not disclosed to them allegedly at the time that they signed off on the transaction, and my client came in and upsized the loan by $275 million. They vehemently claimed in the preliminary injunction hearing, and they alleged in their complaint that they never knew about the participation agreement, never saw it. That's what their witnesses swore to. They didn't know that it contained a transfer restriction that would have prevented a transfer by the junior participant in the senior mezzanine loan to CMB without getting consent from my client, Rubin Brothers. Well, just a couple weeks after the decisions came down, we had another hearing in California, and the night before that hearing, we received their first document production. And in that document production, we were shocked to see an email. We were shocked to find an email from July 14, 2020, which was 2 months before the upsizing transaction, that was sent to Mr. Lee, who's the chief investment
Let me interrupt
advisor.
for a second, because I know you're getting to the term sheet, and that term sheet indicates that they knew about the participation agreement. Reading their fraudulent misrepresentation claim on its face, it seems to be saying that the fraudulent misrepresentation wasn't necessarily just concealing the participation agreement, but that a representation was made about how the proceeds would be used, and they were not used in the way that they were represented they'd be used, and instead there was a fraudulent scheme to just sort of take over the property. Why doesn't that on its face state a valid fraudulent misrepresentation claim?
So the term sheet, interestingly enough, also indicates how the money was going to be allocated from the loan. And so if you turn to the record for the motion to dismiss at page 1008, or 1008, you'll see that it outlines in detail how the $275 million was going to be utilized. It says that not for construction, $68 million was going to be used to reimburse CDCF for advances it made before it sold its participation interest. $67 million was going to be reimbursing various advances for my client relating to closing costs and project costs unrelated to the construction. $65 million to establish an interest reserve. In fact, it specifically says that only $75 million was going to be held back for construction, but even as to that $75 million, you have to read that in conjunction with the loan agreement, which says if there's a maturity default, those funds are not going to be dispersed.
You're saying as a matter of law, the term sheet, and it's undisputed that they had that term sheet, undercuts their fraudulent misrepresentation and fraudulent concealment claim.
Correct. On the participation agreement disclosure, it clearly refutes that. There's a reference to transfer restrictions in the 3-page portion of this term sheet that discusses the participation agreement. They claim in their papers that not having transfer restrictions was critical to them in the negotiation of this document. They had 2 partners at Lewis at Brisbois that were representing them on this because they had $450 million in the deal, and they wanted to be protected. They were copied on the email that enclosed the term sheet. There's not a better example I could imagine of somebody being on actual or inquiry notice to make some questions about that.
What about the breach of implied covenant claim? That even if you had the right to do everything you did, and you had the right to enter into a participation agreement, that you couldn't do it in the way that you did it, that the way you did it undercut their right as a junior lender to have an opportunity to participate in the senior mezzanine loan, and that you couldn't do it in that way. Why is that invalid as a matter of law?
The implied covenant can't be applied to vary the terms of the parties' agreements. And so what they rely on to say that they had this right...
They're relying on the intercreditor agreement, right?
Right.
And the intercreditor agreement doesn't provide what they say it provides. It didn't give the plaintiff an absolute right to acquire a portion of the senior mezzanine loan without consent of the senior mezzanine lenders.
That's correct. Section 4C of the intercreditor agreement that they rely on does not provide any right to CMB to buy anything, and it doesn't give any obligation to the senior mezzanine lender to sell anything. There's a part in the beginning of that...
There was a point when they had a right, but they had to exercise that at a specific point, which they failed to do.
That's correct. So there is a purchase right in Section 13A, I believe, of the intercreditor agreement, but it's a one-time purchase right to buy the entire senior mezzanine loan plus the mortgage loan. They didn't want to exercise that right when they got the purchase notice because I think it would have cost them close to $2.5 billion to buy out those senior positions. So they chose not to exercise the right. Instead, they waited while my client pumped tens of millions of dollars into the project to safeguard the property. And then after we did that and we exercised our UCC right to foreclose, they sued us and they claimed that they didn't know about the participation agreement and that they would have bought the loan if they had been able to exercise this alleged right to buy a portion of the loan. But there's nothing in the record, Your Honors, that shows them ever even trying to buy a portion of the loan. There was never any offer to buy a portion of the loan. And so this, from our perspective, this was all cooked up after the fact because they were trying to find a way to salvage their position. They're completely underwater, and so they wanted to come up with a salvage their position. On the injunction...
We're going to let you get to that in your rebuttal.
Thank you.
Good afternoon, Your Honors. I'm Peter Shapiro, the local lead counsel for the respondent, and I would ask that you permit my colleague Jonathan Preziosi from across the Hudson, who's been admitted pro hoc vice, to argue the appeal.
Permission's granted.
Thank you very much. Good afternoon, Your Honors. Again, Jonathan Preziosi from Louis Brisbois, representing the respondent, CMB.
Let's start with preliminary injunction.
Yes.
Where is the irreparable harm? Why isn't this a classic case where even if you were successful in the merits, you could recover anything in a money judgment?
Right. Yeah, and Your Honor is aware in support of the proposition that irreparable harm exists under these circumstances. We cited to the Zorlu Energy Electric case, a First Department decision in which there was a claim by the plaintiff that the underlying loan transaction was the product of fraudulent inducement. And on that basis, the court enjoined the foreclosure sale until the validity of the security interest could be determined. And that is precisely what we're seeking to do here. We've presented beyond a prima facie case, we demonstrated with a reasonable likelihood of success on the merit.
Let's ask about that. How are you going to deal with this term sheet? There's no dispute that your client got this term sheet. This term sheet disclosed the existence of the participation agreement and many other details that form the basis for fraud claims. Why shouldn't they be dismissed on the ground that they're insufficient as a matter of law? Because there's not really any particularity. What is the particularity about this supposed scheme to just take over and liquidate everything and wipe out your interests?
Well, under the special knowledge doctrine, the issue becomes whether the plaintiff, through the exercise of ordinary intelligence, could have discovered the information that was allegedly...
How does the special facts doctrine come into play where we have this term sheet which disclosed the participation?
I'm just about to get to that, Your Honor.
Okay,
It's not.
I'll let you get to it.
Thank you very much. It's not the fact that there's a participation agreement that is the fraudulent non-concealment. It's the terms of the participation agreement. And let me just put it in context.
I mean that there were transfer restrictions.
Well, no, that there would be a prohibition against transfers specifically to my client, CMB.
And what's wrong with them doing that?
Well, because the intercreditor agreement doesn't contain any such prohibition. Justice Friedman, you make a good observation that Section 4C of the original intercreditor agreement doesn't give CMB a right to buy up into the stack of creditors, but it gives it the ability to do so.
Counsel, what about the language that says that the senior mezzanine agent and the senior mezzanine lender may act in any manner it or they deem appropriate regarding the administration of the senior mezzanine loan, and that any act or omission may not be deemed for any purpose to comprise interference with the rights of the junior mezzanine lender, your client?
Yes, and as Justice Ostringer determined, that is not exculpatory language that would exculpate a party from committing a fraud, which is what occurred. Justice Ostringer had a full-day evidentiary hearing listening to this, and he saw the fraud. The original intercreditor agreement does not make CMB a prohibited transferee. We get to the day that the Fourth Amendment to intercreditor agreement is signed. Yes, Judge.
Where does the duty arise for them to disclose the details of the participation agreement. Where are you getting that duty from?
Under the special knowledge doctrine, because only they knew that in that agreement, they were naming CMB a prohibited transferee. At the time, the Fourth Amendment to Intercreditor Agreement was being signed. And that's a document, by the way, through which CMB consented to Rubin Brothers' participation. CMB has the original intercreditor agreement that does not make it a prohibited transferee. It has the Fourth Amendment to Intercreditor
Let me
Agreement.
ask you something. Why didn't a duty to, you're relying on the special facts doctrine, why didn't a duty to inquire arise once you were aware from the term sheet that there were certain transfer restrictions? So you were on notice that there were these restrictions. Where did you then inquire and say, hey, what are these restrictions? What's going on? What's happening here?
Because, Your Honor, the very same day, September 1st of 2020, Rubin Brothers was signing an agreement with us that kept our ability to purchase up into the stack completely intact. The Fourth Amendment to Intercreditor Agreement, our agreement, preserved our ability to negotiate to purchase an interest in the senior mezzanine loan. So entering into an agreement with that party
You didn't
that
have to
day.
exercise that right at a certain point? I mean, it wasn't an unfettered right.
Your Honor,
That's what I don't understand. I mean, we know that you knew about this, and look, we're dealing with very sophisticated parties, and we're dealing with large sums of money. Don't you insist either to see that participation agreement, or at least include in your agreement, in your intercreditor agreement, provisions to deal with what's happened to you?
We did, Your Honor, and we did by preserving the original Section 4C of the intercreditor agreement that gave us the ability to purchase an interest in the senior mezzanine loan. So this is my point. We're entering into an agreement with Rubin Brothers on September 1, 2020.
But didn't your adversary say it gave you that right, but you weren't going to exercise it then because it required you to put in too much money?
Oh, no, Your Honor. At any point in time, we may be confusing two separate purchase abilities. The second, which was referred to by Mr. Parrott, is a purchase option event, which is after an event of default, the junior mezzanine lender has the right, if it has the funds, to cure the default. We're talking about something completely different. We're talking about Section 4C of the agreement. Now, again, the very moment we're signing an agreement with Rubin Brothers that keeps our ability to purchase up into the stack intact, Rubin Brothers is signing an agreement with another party, CDCF, that specifically targets CMB.
Thank you. Do you have any further questions? Thank you.
Thank you.
Just very quickly, the participation agreement did not destroy any right to negotiate with the senior lenders to buy or request to buy a partial interest in the loan. They just never did that. All it said was that we would have to consent to a sale, and there's nothing wrong with that. The irreparable injury Your Honor asked about, they're a mezzanine lender that gave a $450 million loan. The amount of their loan, whatever interest is accrued, whatever fees, attorney fees that need to be added to that, that is the precise measure of their monetary damages. They can't establish irreparable harm. The Shelbourne and Broadway 500 decisions from this court both stand for that proposition. The Zorlu case, the Invar versus Zorlu case, distinguishable because that involved a party that claimed an ownership interest in the subject property. So that's not the situation here. You have a mezz lender that's several tiers removed from the ownership of, and has no ownership stake in the borrower entity. On the balance of the equities, we would just ask that the parties be required to observe the agreements that they signed. These were highly sophisticated parties who negotiated the intercreditor agreement, clearly says that their interest was subordinated. And if the court decides not to reverse the injunction, we would ask that the bond be increased to $200 million. $5 million is outrageously low. There was no analysis given by the lower court on that number. the interest on on these loans is accruing at $25 million a month. So we're talking about a week's worth of interest, essentially, that bond would cover. This has been going on, it'll be a year in February, and our client's probably never going to recover that money. So if the injunction's going to stay, we would just ask that the court increase the bond. Thank you.
Thank you. Andino versus Wizard Studios. Eeny, meeny.
Good morning, Your Honor. Good afternoon, Your Honors. My name is Debbie Ann Morley. I am with the law office of Marshall, Conway, Bradley, and Gullub. My office represents KM Productions, Inc. in this matter, if it pleases the court. We filed the initial appeal on the issue of grave injury. We feel the lower court was incorrect in finding an issue in fact as with respect to the issue of grave injury. The plaintiff was an employee of my client. There was workers' compensation benefits available to her. That is the sole remedy. Without a proof of grave injury, the allegation has been that she suffered.
There's clearly an allegation by her expert that she has suffered a grave injury, that she suffered brain damage. Why isn't that enough for the claim?
Well, initially, the plaintiff's expert, Dr. Krishna, his records are completely devoid of any reference to the permanency of her alleged brain injury. It was not until his affidavit, which was submitted in support of the instant motion, that permanency was brought up. In fact,
So you're saying we should disregard the final opinion because it's not supported by his record?
it is not supported by his record, nor is it supported by the plaintiff's own testimony as to her abilities. The plaintiff testified that not only is she able to utilize a computer, she searched for jobs, created her own resume, applied for hundreds of jobs. She's able to drive herself.
But again, what do you say we do with the fact that the plaintiff's own doctor's records doesn't reflect that she's totally disabled?
Well, there is no question there. If she is not permanently or totally disabled, as a matter of law, she cannot be found grave injury, and you rule in the favor of KM, reversing the lower court's decision and allow the third-party complaint to be dismissed.
Okay, any other questions?
No.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. I'm George Ilkert from the law firm of Hack and Rose, and we represent Renee Andino in this case. She was a stagehand that fell from a
Let me
trust.
ask you something. We're familiar with the facts. The 240 claim, don't we have a line of cases from the First Department that say where stagehands are performing cosmetic work, that does not constitute a 240 claim? And based on the facts of this case, where it's undisputed that the trust was already erected at the time she came and they were putting banners up, why doesn't this case fall under those cases as being cosmetic work, not within the rubric of 240?
It doesn't fall under cosmetic work because the trusses have to be constructed, the banners
the
put on,
trusses were
and
constructed.
disassembled and taken away, Your Honor, and taken away.
Counsel-
Same with the set.
Counsel, they were assembled. She did climb.
But that's isolating the conduct. The contract provides for the construction of this, putting all of the material on it, and then taking it down.
But counsel, the focus for us would be the work that she was actually doing. She wasn't constructing, she wasn't modifying, she wasn't altering, she wasn't, I don't know what you call it, undoing the trusses. It was cosmetic.
The work that she was performing was part and parcel of the work that was contracted
But
for.
why should we look at any work other than the work she was hired to do and the work that she was performing? Why are we looking at the whole project? Why are we?
Okay. In the case of Mullins against Centerline, 3 of the justices on this panel were on that case. It was a stagehand who was stapling faux brick into a set.
You're suggesting because at some point in the future they're going to take down the trust, that should bring her under 241, even though they're not taking down the trust when she gets injured.
But it's part of the work that's contracted for under this project, Your Honor.
But her job was to put the banners up. That was
At that
the
time in
stagehand,
isolation.
And you had a fully constructed truss, and she came in more like an independent contractor to put the banners on, correct?
No.
That was her job.
No, Your
Now, she did other gopher work, maybe pulling cables, but in terms of that truss, her job was to put the banners.
Was
Like changing a light bulb.
Was it her job to put those banners up, or was she supposed to be doing stagehand work
At the
on
time, at the time of the accident, she had the general duties of a stagehand and to do what she was instructed to do in this particular case,
And
put those banners up.
Isn't there testimony that she was told not to climb?
Her testimony?
No.
Oh. No, not her testimony. Her testimony is that she had hung other banners in the full view of the supervisors, Wizard, Mosaic, etc.
Let me ask you about the 200 claim. What evidence is there that Wizard or Mosaic actually exercised any supervision or control over her work?
They were there at the time, directing and supervising what was going on.
Right, but a general duty to supervise is not normally enough in the cases. They actually have to be supervising her work for a 200 claim. What evidence is there to support that they were supervising what she was doing as a stage?
That they saw the work going on, Your Honor.
But they didn't control the means and method. That's totally KM, right?
They could have. They could have controlled the means and the method.
Whether they could, they can have certain but based on the case law, is there anything in this record that shows that they were directly involved in the means and methods of what your client was doing?
I don't believe she spoke to them. And as regards the 241-6 and the 200 claim, the court correctly decided that 200 was still in play and that there was a violation of the industrial code for 241-6. And the affidavit of Dr. Krishna,
How was the industrial code involved, or applicable rather, where K&M didn't provide the harnesses, but rather she brought her own harness, even though she was a stagehand? She brought, there's testimony that all the riggers on the job brought their own equipment. So how is 23-1.6 implicated here?
Because, Your Honor, it's the duty of the fee owner and the contractors to ensure that equipment is provided.
But she was a stagehand, counsel.
I understand. Testimony of Mr. Parrish, supervisor. Would you have, as part of your job as a supervisor, have inspected the harnesses of the climbers to confirm or learn whether they had shock loaders and positioners as part of their equipment? Answer, no. He's totally admitted to violating the labor law and that they didn't care what went on.
He also testified that plaintiff wasn't permitted to climb the truss, right?
I'm sorry?
You also testified that plaintiff wasn't permitted to climb the truss.
It wasn't permitted? I believe there's testimony that she
Isn't that
was
what he
directed
testified to?
What's that?
Isn't that what Parrott testified to? That as a stagehand, she wasn't permitted to climb the truss?
I don't believe so.
No.
Thank you.
Thank you.
Did you have a question?
No, I'm okay.
May it please the court. Good afternoon, Your Honors. My name is Faizan Habib from Tyson and Mendez for defendants, cross appellants AT&T, Mosaic, and Wizard. The motion court should have granted AT&T, Mosaic, and Wizard's motion on the issue of liability under Labor Law 200 and common law negligence, as there is no evidence, as the court so aptly noted, of the requisite level of supervision and control to impose liability on an owner or general contractor. Neither Mosaic nor Wizard supervised any of KM's work or the plaintiff's work specifically. All of that work was exclusively directed, controlled, supervised by KM Productions. Wizard's role and Mosaic's role was that of general oversight, monitoring and controlling, monitoring and oversight of the timing and quality of the work, and telling KM Productions what needed to be done, not how to do it. How to do it was all exclusively the province of KM Productions. With respect to the 240 issue, again, as the court so aptly noted, the line of cases as to the applicability of 240 in this circumstance with a stagehand is applicable here. The Adair case is almost directly on point.
What about her argument, her argument that you have to look at the work in its context, and the work in its context generally involves work that would normally be covered by 240?
One of the arguments made in plaintiff's reply brief was that the St. versus Syracuse case should be controlling here, as it requires a contextualized analysis of what the plaintiff was doing at the time, and that Adair predates that analysis and should not be followed. But this court has, in Royce v. E.H. Digg, utilized both Adair and St. And as such, I think Adair is still good law. I don't think the contextualized analysis, even if it were to apply, we would look at what plaintiff's job role was, what her job function was. She was a stagehand. She was responsible for ground level duties. There's testimony that she was not allowed to climb, and she did so anyway. Excuse me.
Sir, in any event, there was no construction going on when she was doing her job?
None.
So by the same parity of reasoning, as there would be no basis for a 241 claim, there can't be a basis for a 241-6 claim, correct?
Correct. The 241-6 analysis is almost identical. It requires a protected activity that the plaintiff was engaged in an inherently hazardous activity of construction, demolition, or excavation. Plaintiff wasn't involved in any of those. She was using zip ties to hang vinyl banners from an already constructed structure.
Thank you.
Good afternoon. May it please the court. My name is Lou Caratenuto. I represent the city of New York in this matter. We are just a respondent at this point. Mr. Faison has articulated all of the reasons why the lower court's decision dismissing the 240 and the 241 case against the city of New York should be upheld. Plaintiff did not move for 200 against the city. The city had no presence on the project. I mean, the record is clear on that. No presence, no involvement whatsoever other than the issuance of permits to the various entities.
What issue is this on the appeal having to do with the city? I mean, the city hasn't moved to dismiss any of the claims. How does the city play into this appeal exactly?
Well, I'm sorry, the plaintiff has moved to reverse the lower court's decision granting.
Okay, so you're just opposing it. Okay, I just want to make sure I'm understanding.
Yeah, so.
Okay.
Because you own the property.
Exactly, we're the
Okay.
property.
I think you asked whether we received your brief. We did.
I'm sorry, Your Honor.
I was
think
just
you asked-
confused, yeah. We have your brief.
We have your brief. I think you asked at the call of the calendar whether we had your brief. We do.
Okay, thank you. Unless there are any questions that
Thank
you'd
you.
like to direct to me.
Thank you.
Thank you, Your Honors.
You have the next minute if you want it.
No, Your Honor, I'm going to waive the
Okay.
reply.
You have a minute then too. If you wish.
Your Honor, under Pratt's rather, if the work that's being performed, even though it's not ordinarily using a jackhammer or something else, as long as it's part of the overall project, is protected under Labor Law 240.
Okay, thank you. Do you wish your minute?
Unless the court has any questions, I stand on my papers.
Thank you. Mart versus Tishman Construction.
Good afternoon, Your Honors. May it please the Court, John Lavelle of counsel to the Barnes firm for Plaintiff Francisco Marte.
Francisco Marte was injured while walking across rebar at a construction site. It's our contention that the rebar should have been covered by plywood planks, as was confirmed by the witness.
And you claim that this gives rise to 241 liability. I think there's a factual dispute whether how far below the rebar, whether it's 18 inches or more or less. But what safety device should have been used here? And if you say it's plywood, how do you put plywood on rebar that you're going to be laying cement over?
So in this situation, Your Honor, it's important to understand the context of what plaintiff was doing at the time that he was injured. He was carrying rebar from a staging area over to the area where the work was being done. So the plywood should have been over the completed area of the rebar so he could safely carry the materials over to the area where the rebar was being installed. So there was nothing to prevent the area from the staging area to the area where he was delivering the rebar to be covered with the plywood and still be able to effectively install the rebar grid at the site.
When was the concrete going to be poured?
When the rebar was finished. So they were doing it in two sections. They completed the first section, and they were in the midst of putting together the second section.
Was that going to be done the same day?
It's unclear to me, Your Honor, what would be done the same day. But they were at a stage where they had not yet completed constructing the rebar mesh. As far as the height differential goes, he's walking across these sections of rebar. There's a height differential, it's in the record everywhere, 18 inches, 24 inches, et cetera. But clearly, given the gaps between the sections of rebar and the squares, the way it was put together, there was more than enough space for him to fall through due to the effects of gravity. It's our contention that this falls under 241 due to the height differential and the effects of gravity. On the other issues on appeal here today.
The amendment, counsel, you want to amend the bill of particulars so as to include 23-1.22C1, which requires a platform in an area used to transport pedestrian traffic. So how would the amendment prejudice or not prejudice your adversary?
I do not see how the amendments would prejudice our adversaries. The discovery was very robust in this case. Depositions were done of the plaintiff, of the defendant's witnesses, of RNC's witnesses. All of the theories were explored. There's no surprise here. You know, in order to establish prejudice, they'd have to establish that they didn't know this was coming. There was something kind of came out of the blue. And these same fact patterns that are described in these industrial code sections are what came through the course of discovery. Also, the original BP, while it did not name the industrial code sections, laid out facts which apply with these industrial code sections. Amendments are to be liberally granted generally, and in this case, we'd argue there's no prejudice to the defendants had the amendment been granted.
Thank you.
Thank you. May it please the court.
Excuse me, Brendan Fitzpatrick, counsel for the defendants, respondents, appellants.
So I'd like to ask you the same question. How would the amendment of the bill of particulars so as to include that section of the industrial code prejudice you in it?
Well, according to this court's decisions, I don't believe the industrial code would have even been applicable. It's not this, you're not talking about a pedestrian walkway or a vehicular walkway, as you've seen in Capobianco.
Why isn't it a pedestrian walkway?
Because, Your Honor, it's the platform that they're looking for. It's really not just for the workers to walk. First of all, he's not a pedestrian. He's a worker on a construction site, an active site where they're installing the rebar that he says there should have been a piece of plywood on top of. So again, I think the facts from 1.22C1, it's a bit
for pedestrian traffic, though. In a construction site, isn't the workers going back and forth pedestrian traffic?
Your Honor, I think it's a
They're the only ones who are walking, obviously, in these sites,
True,
but they had to go back and forth to do the work.
But it's a different factual scenario than what we have here, where we have testimony from every single witness saying these workers are trained to walk on the rebar. That's what they're supposed to do.
Doesn't mean it's not a walkway. It means that you're claiming they're trained to walk on this walkway.
Yes, but again, Your Honor, I think having plywood on it, first of all, if the plywood's not on it, then the provision doesn't apply in the first place. It's almost some cases where if you...
that provision is the best of the amendments, the best of the industrial code provisions they want to allege now. But in terms of whether there's privilege by the amendment at this point, I mean, doesn't that very discussion here show that this is something which is subject to factual give and take.
So
The
what?
23 point, to now amend to 23.1.22C1.
Yes, I believe it's different, and I think it's a different factual scenario than what all the witnesses testified to, whereas they all said you wouldn't need plywood for these workers to have access to the area where they're working.
You're basically,
Well, I'm not sure. That's not how I seem to understand it, so you can try and clear it up for me. Generally, I guess they are trained to walk on rebar, and I understand that. But we have two different scenarios here. We have a pathway for them to get the rebar and carry these heavy things from point A to point B safely without having any accidents, because their balance is off when they're carrying something heavy. Otherwise, being able to walk on rebar is kind of like ice skating, I guess. And then we have the issue of whether, how do you lay down a platform when you're about to pour the cement, as was raised earlier?
Yes.
Correct. So which suggests that issues of fact, no?
Well, Justice Friedman, I'm not ignoring your question, Your Honor, but when you reference when it was supposed to be poured, Mr. Rosario, page 710, says it was probably going to be poured within 2 or 3 days. So again, they were still actively putting down the rebar that was eventually going to be poured. And I believe it was Mr. Patton who went through the sequence of events as to what had to be done.
You're looking to have the 241 dismissed. Why isn't there an issue of fact whether or not the plywood should have been put down here?
One, I think if you look at the Salazar case from the Court of Appeals, it would have been, in the words of the Court of Appeals, in Mr. Lorenz's expert opinion, and I believe the testimony of all the witnesses, it would have been illogical to put plywood down on the very work that these guys are actually performing.
But if the concrete was going to be poured 2 or 3 days later and you have them walking on it, perhaps there should have been plywood on it for a couple of days.
Again, Your Honor.
Does that not generate an issue of fact?
I don't believe so, Your Honor, especially if you look at Mr. Arguetta's testimony, and he was the RNC General Foreman. When he was pointed to the area, the X where on the photo where plaintiff said he fell, he was asked, would you put plywood there? And he said, how am I going to put plywood there and get my work done?
Counsel, but that does beg the question. I mean, in my mind, we're talking about the difference between having someone walk on basically a skeletal structure as opposed to a flat surface that is not penetrable. So the timing here perhaps is what raises the questions for us. If you were talking about, you can't put it down because everything is ready and now we're going to do the pour, as opposed to we're setting everything up and the pour is going to be done in 2 to 3 days. That's where we keep finding, listening to what my colleagues are saying and my own thinking, that's where we're saying, isn't there a question of fact? And does the amendment hurt you in any way? Does it, you already know what the layout is.
May I just briefly answer that? Your Honor, I think I would again go back to Mr. Rosario's testimony and Mr. Lorenz's expert opinion about the sequence of events and the fact that the plywood was not necessary for the work that these RNC workers were using, that they were doing at the time, and according to all these witnesses, it would have actually inhibited their work in the area where plaintiff said he fell. It would have inhibited their work to have the plywood placed there. So,
does the record reflect this 2 to 3 day period?
Mr. Rosario, I believe page 710 of the record, when he said he believed it was within 2 or 3 days that the accident. So it's different than the Brown case, which the condition had been there at least 2 weeks, essentially unchanged. This was an active site where they were installing the rebar that was eventually going to be poured after the inspectors inspected it.
The 2 to 3 day period has a record basis.
Yes, page 710, Your Honor.
Unless the panel has any further questions.
I do.
Yes.
So is there any indication as to how the work would be inhibited if a plywood platform was installed as flooring for walking?
So this goes back to what the plaintiff is doing is important here. So What he's doing is transporting materials. I could understand if you had a piece of plywood over you.
Is there anything that says that the work would have been inhibited by putting down a platform other than to say, in the event that we were doing an immediate pour?
There's only vague references to it interfering with them being able to install the rebar, but he's transporting materials, not in the installation process. And Mr. Argueta was very specific with site safety being the most important thing, that he would accept delays in exchange for safety. And the most safe way to do this would be to lay this plywood down. You screw together the sections of plywood. It provides a means of egress on and off the site for protection of everyone, including the plaintiff, especially with what he was doing at that time.
Would you agree that if the pouring of the concrete was to be done immediately, that you wouldn't have a 241 case?
Not necessarily due to the size of the second floor of this building and how large it was, so you could begin pouring on the far end and still maintain the means of ingress and egress and pull that back as the pour approaches it, so not necessarily.
Thank you.
Thank you.
Briefly, to answer Your Honor's question, Mr. Rosario, page, I believe, 549 of the record said, we specifically with respect to the area where plaintiff fell in the X that he marked on the photograph, in quotes, how the hell are we going to build a building when the plywood is on top of the rebar? Mr. Argueta, page 624 to 26 and page 710 to 11, he could not put down the plywood in this area because they were still installing the rebar. Unless there are any further questions, I'd ask the court to reverse. Thank you, Your Honors.
Merrick versus Masaryk.
May it please the court. My name is Georgia Carconnect from the law firm Kaufman, Delowich, and Volokh, and we represent the appellant defendant, ThyssenKrupp Elevator Corporation. The specific issue that I'd like to address today in this appeal is whether the lower court erred in its decision to grant Masaryk defendants conditional.
Let me ask you something. For us to grant them or affirm the grant to them of the conditional indemnification, why do we have to determine either party's negligence? Can't we come to the determination that was appropriate without deciding your client's negligence or their client's negligence?
Your Honor, it's my position that we don't even need to reach the issue of negligence because the provision at issue violates the GOL 5-
Well, the GOL is only violated if you are indemnifying someone for their negligence. But doesn't this provision say that they're in fact going to indemnify you if they are ultimately found to be negligent, and that you're not supposed to indemnify them for their negligence? You're supposed to indemnify them, that's why it's conditional, only if they're found not to be negligent. If a trial happens and they're found to be 100% negligent, and you're found not to be negligent, then there'll be no indemnification. So how can it violate the GOL?
So, Your Honor, by awarding conditional contractual indemnity, the assumption is that the provision is valid in the first place. It's void and unenforceable on its face.
There's a savings clause, counsel, isn't there?
There is no savings clause in the provision at issue. There are two separate indemnity provisions that are written into this contract. One is from Thyssen to the Masaryk defendants, and the other is from Masaryk to Thyssen. Now, with respect to the indemnity provision that was cited to, the savings clause that was cited to by the lower court, that language is found in the indemnity provision from Masaryk to Thyssen, and that is for anything arising out of the common, the willful misconduct or negligence in the common property. In the indemnity provision from Thyssen to Masaryk, it involves the elevator at issue and the performance of the contract in that respect. In that indemnity provision, there is no savings clause. The language isn't the same.
You're talking about the difference between Masaryk saying obliged to indemnify Tech for Masaryk's negligence as opposed to actual or alleged negligence on behalf of Tech? Is that the difference that you're pointing to?
Yes.
That
in addition-
Masaryk doesn't have actual or alleged the same language?
Well, it's specific, and it's, what I'm referencing is that the language in the second indemnity provision talks to incidents that occur on the common property. This is on 185 of the record, Your Honors. The second provision is specific to Masaryk's, with respect to negligence on the common property. In the first indemnity provision, which is what was awarded in this case, and it's only relevant with that provision, there is no, in addition to active negligence and willful misconduct, there's also the alleged negligence, and it's a much broader language. It says any and all liability arising out of.
So you're saying that if the language is not identical, in your view, it's violative of 322.1?
Yes, on its face, it would be violative of the general obligations law. And specifically with respect to the GOL, recently in this court, in Alvarado, the court said that in order for it not to violate the GOL, it has to have that language that says to the fullest extent of the law, or to the extent provided by the law. None of that language is included in that first indemnity provision that provides indemnity to Masaryk. And for that reason, I would ask that the court reverse the lower court.
Thank you.
Good afternoon, Your Honors. May it please the court, George Colby from Raven and Colby on behalf of the respondents, the three Macerich entities. The identification provision at issue here, Section 6 in the agreement, does not violate the general obligations law. It does not
Is there
require.
any significance to the fact that the counter indemnification speaks of active negligence or willful misconduct as opposed to just negligence when you're talking about TEC's indemnification?
Well, it says if Macerich is negligent in the common areas, which would include the freight elevator, that is a common area. Anything outside of lease space is a common area. Macerich is going to indemnify and defend.
It says the
TEC.
page 185,
Yes.
active negligence or willful misconduct by Macerich. That's where your liability, that's when Macerich has to indemnify. Is there any significance to the fact that for Macerich we speak of active negligence and for TEC we speak only of negligence?
I don't know if there is a difference between active negligence and negligence. If Macerich is found negligent, they're not entitled to indemnification as the lower court has determined. And if Macerich is found negligent in causing this accident in the freight elevator, then Macerich has to defend and indemnify TEC.
Any more questions? Thank you.
Thank you.
Your Honors, with respect to whether or not there is a difference in the language that says active negligence or just the broader negligence in the first indemnity provision, our position is that the two are completely separate and distinct, and that the indemnity provision at issue talks about any and all liability as well as the alleged negligence.
Any dispute that if the trial is held and Masaryk is found to be any part negligent, it's not going to be indemnified for any portion of what it's found to be negligent in this case. Tyson's not going to have to indemnify it. Do you disagree with that?
I do not, Your Honor, but more.
So if that's the case, how can allowing this decision to stand be indemnifying it for its own negligence, because it won't be indemnified for its own negligence?
Because then we're setting a standard to say that the language employed in this contract.
So we can't read them together? Is that
No, they're separate and distinct. The obligations,
so the interplay in terms of what the ultimate obligations are of indemnification?
That is true, Your Honor, but each could independently be taken on their own with respect to other scenarios. And with the language as it is with respect to that first indemnity, saying any and all negligence, any and all liability arising out of the alleged negligence, awarding Masserick conditional indemnity provision gives credence to that type of language without the enforcement of the GOL, and it doesn't satisfy this court's holdings in prior cases that require the limiting language.
Thank you.
Thank you.
You too.
You.
People versus Tolbert.
Good afternoon. Simon Greenberg on behalf of Eddie Tolbert. The prosecution here improperly filed 6 extra record documents in this court to
Sir, if we can get to an issue that's really been troubling me in this case in understanding your position.
Yes, Judge.
Your core position is to somehow determine that the manner in which Mr. Tolbert was determined to be a level 2 offender for the New Jersey rape in 1991-92, there were certain factors or certain information that was considered that was erroneous, among other issues. So, in a sense, you're seeking a downward modification.
Well, I'm raising 3 arguments. The first, yes, Your Honor.
You're seeking to have to revisit the whole findings of the SORA court for what happened in New Jersey, correct?
Well, we're seeking to have this court rule that the lower court erred in holding that Mr. Tolbert was required to register in New York for this conviction.
Fair enough.
And
what I
also,
need to understand now, let's accept that for our purposes.
Yes.
What appears to be undisputed from the briefs was that in Brooklyn, for the rape of his granddaughter, he was determined
his granddaughter, Your Honor.
It was his daughter?
Granddaughter.
That's what I just said.
Oh, I thought you said, I'm sorry, I misheard you.
Okay. He was adjudicated at a SORA hearing to be a level 3 sexually violent predicate sex offender. So if he's already determined to be a level 3 sex offender by a SORA court, what is all this all about here?
Well, what it's about, Your Honor, is that Mr. Tolbert is required to have a SORA hearing in the Bronx, or for the New Jersey conviction that's separate from the Brooklyn conviction. No one, the lower court, the parties don't dispute that this SORA hearing was required to be held, and then at the SORA hearing, of
You're
course.
saying it doesn't matter if there's a prior adjudication. You have to do it for each. Each offense has to have its own SORA hearing, even if they're already a level 3.
I think in this case, it was necessary to have the SORA hearing here, except for our argument, of course, that.
Right, but you're saying if you go out and convicted of 3 separate sex offenses, you have to have 3 separate SORA hearings.
I think in this circumstance, the answer is there are required to be 2 separate SORA hearings because one of the offenses occurred in New Jersey, not even in New York State, whereas one of them happened in Brooklyn. And there is case law talking about consolidating hearings into one hearing.
The other one already happened. So.
That's, that had already happened by the time this
Let
case
me
was
ask a question.
calendared.
Assuming the court, that the people cannot now introduce new documents that were not introduced below, based on the way that things played out in the court below, where the court really did not give the parties an opportunity to submit the documentation that they wanted to submit, why isn't the appropriate remedy in this case to simply not allow the people to submit the additional documents here, but to remand so that a full hearing can be held and the court can make a determination about the timing of the sentencing and the other offense to determine whether or not the offense in New Jersey should have a SORA hearing here?
Yes, Your Honor. So, yes, this court cannot consider the extra record documents.
I'm assuming that's true for purposes of my question.
But as to the question of whether the case should be remanded, the district attorney on the record did not ask for an adjournment, and we dispute the characterization respectfully.
Counsel, I don't know that really works. didn't the court say that a decision would be issued by July, and then it made the decision the next day? So there was no opportunity to ask for an adjournment. There was only an opportunity to submit documentation before the decision was issued.
We disagree with that, Your Honor, because when the court asked the district attorney for its position on the question of registrability, the district attorney said we weren't prepared to address that argument. And instead of asking for the district attorney could at that point have said, and we would like an adjournment to obtain documentation to respond to it. And also, the other thing, Your Honor, is that when the court said the case, I'll reserve decision and issue a decision in July, which is what the judge said, and said to the parties, if you want to, you can submit a post-hearing submission. The prosecutor didn't say anything at all.
But if he said you could, why wouldn't the prosecutor walk away with the understanding that they could? And the only reason they couldn't was because the decision got issued so rapidly.
Well, we think that the prosecutor could have made their position clear on the record by saying, yes, Judge, we acknowledge that you're giving us this. Because the judge said if you want to, and the DA didn't say we want to, they said nothing.
I'm sorry, is it clear that they said, no, we're not going to submit anything? I mean, wasn't it left open?
I think that the DA should have been clearer and should have said, because the judge was offering, saying if the DA wanted to, not you have to, and the DA didn't say anything about whether they wanted
Why shouldn't the court have the opportunity to look at these documents and make a determination and address the argument you're making?
Not here, Your Honor, because
Not here,
because the
nevertheless.
prosecution did not seek an additional opportunity to present the evidence that they're seeking to present now.
Thank you.
Good afternoon. May it please the court, Maria Wager for the Bronx District Attorney.
What's your response to that? That you should have made it clear on the record that you were seeking an extension of time to submit additional documents. The people did not do that, and they're foreclosed from now submitting additional documents to be considered.
Yes, Your Honor. The court did not ask a question. The court did not say, does either party want more time? The court made a statement and said, I am putting this over for a full month, and so if you want to submit anything, you can. So there was nothing to reply to. And I would just note that the assistant who was doing the hearing was not the assigned assistant. She was standing in for another assistant, so perhaps she didn't want to speak for that assistant, but I would just point out the court did not ask. And so the people did not have to answer. Maybe perhaps she didn't know if the assistant
If you got
planned.
the decision, did you do anything in terms of going back to the judge and say, well, look, we have more material to submit?
Well, we had no recourse, Your Honor, because we were victorious. We got everything we asked for. We asked to adjudicate defendant in accord with the
You got what
boards.
you wanted.
Right, so there's no recourse. We couldn't move to re-argue. There really was no recourse at that point to support that
You weren't an
finding.
aggrieved party. You weren't an aggrieved party.
Correct, Your Honor. So we really had no recourse. We were victorious, and so here we are.
So do you think we should remand it for the court below to consider the additional documents? Is that?
I do, Your Honor. I do think this court could take judicial notice of those documents. I think this court could also exercise its interest of justice review power, which is frequently exercised on behalf of defendants. However, this court does have the power to exercise it in favor of the people, and here in favor of the public good, which is the whole aim of SORA. I think the documents speak for themselves. I think defendant's position relies on a falsehood that he was not still serving his sentence at the time this amendment went into effect, when he was, indeed he was. But to reach—
the fact that he'd then be a level 1 and you can argue for an upward departure?
We would ask if this court in its power did not grant the upward departure to remit for the people to make that argument. So if the court is going to remit the case. We asked that the hearing be reopened because we were deprived of the opportunity provided in the correction law 168N3, where there's a dispute. The court shall adjourn the hearing as necessary to permit the parties to seek the proper documentation. And it also should be remanded for the people to make an upward departure application.
Anything else?
No, if the court has no further questions, I'll rest on the brief. Thank you.
Thank you very much.
Very briefly, Your Honors, to respond to the prosecutor's argument that our position rests on a falsehood, the argument here is that the prosecution did not meet its burden of proof of clear and convincing evidence to prove that Mr. Tolbert was still serving his sentence on the effective date of the legislation that expanded the definition of a foreign state sex offense. So the burden never shifts from the people, and that their burden is to introduce evidence to prove their position. And so we're not taking any false position by holding the prosecutor to its burden of proof. In addition, although if the court does remand to give the DA an opportunity to seek an upward departure, they should be limited to the risk level, at most, the risk level that was assessed at the original proceeding, because the point of a remand would be to give them, if the court believes they're entitled to that, another opportunity to make their record, and they should not be able to get any more relief than they originally sought at the original hearing.
Thank you.
Thank you, Your Honor.
Diaz versus New York City Health and Hospitals Corp.
Good afternoon, Tahira Sadria, appearing on behalf of the defendants' appellants. This court should grant defendants summary judgment dismissing the complaint. The plaintiff has failed to raise a triable issue of fact on any of their claims of malpractice, and there's no evidentiary basis for any of, because there is no evidentiary basis for any of their theories raised. With respect to Diaz, the plaintiff's expert posited 3 possible causes of the symphysis pubis separation: excessive pressure, prolonged hyperflexion of the legs, and the failure to allow relaxation of the legs between contractions. But there's no evidentiary basis to support any of these theories. This was a relatively rapid and uncomplicated delivery. There was no need for instruments, no problem delivering the head or shoulders of the baby, no basis. And so therefore, there's no basis for a jury to find that any of the defendants applied excessive pressure. And similarly, with respect to the prolonged hyperflexion, the plaintiff's expert never defined what prolonged actually means, but here the legs were flexed for a maximum of 35 minutes, which defendant's expert said that this maneuver can safely be used for up to 2 hours, and that was never refuted. And similarly, there's no evidence that plaintiff was not permitted to relax her legs between contractions, and if that had been an issue, plaintiff could have put in some kind of an affidavit, either by herself or else by one of her relatives who was present in the room to attest to that. Likewise, nothing supports the malpractice claim with respect to the child. If the court has no questions.
Any questions? Okay, thank you
Then
very
I'll
much.
rest to maybe, thank you.
Last case on the calendar being argued, People versus Unger.
May it please the court, my name is Michael Blakey. I'm appearing for Matthew Toohey. I did not write the brief, and I did note that on my notice of appearance. Thank you. The pretrial application in this case was denominated by the people and recognized as such by the court as a Molyneux application. This was not a Molyneux application. No characterization of the evidence of the 2011 accident could be called an uncharged crime.
So,
It should have been more
Counsel-
precisely denominated
to
a
the extent-
ventimiglia
You
hearing.
have to stop if someone has, if the judge has a question, you have to stop them.
Hello?
Hi. So, counsel, to the extent that we might agree with you, then would the relevant standard be relevance and probative value as opposed to potential prejudice to the defendant?
Well, I'm going to concede that the 2011 accident was relevant to the knowledge of the defendant of what could happen if he didn't take his medication. The problem here is this was characterized as a prior bad act, which was ventimiglia. In other words, that he intentionally did not take his medicine. And this is the problem. That was an inference that was not based on any evidence, and that was compounded by an expert relying on medical records that did not contain that information either. There was no proof that he intentionally failed to take his medication in 2011.
Point of the evidence that he didn't take the medication, and because he didn't take it, he now knew what could happen if he didn't take his medication.
Right, that's
that
why
being
it
submitted?
was relevant, and the fact that at 2011,
But isn't that what it came in for?
no, it came in to prove that he intentionally didn't take his medication on more than one occasion. That's what it was out for.
Where are you getting this intentional, as opposed to just that the existence of the fact that he didn't take his medication and he knew what would happen if he didn't take his medication?
I'm sorry, I don't understand.
Where are you getting the intentionality argument about? Where's that coming from?
Well, the people characterized it as admissible for the proof that he intentionally didn't take that medicine, and their expert testified to that.
So, but in order to prove recklessness, right, did intention have to be proved?
State of mind has more than one application to various facts. So there's an overall whether the act was intentional or not, but specifically whether he intentionally did not take the medication is a separate analysis.
But as my colleague was alluding, isn't the issue knowledge of consequences? Wasn't that the real issue in this case where he ends up being convicted of manslaughter, 3 counts of manslaughter 2? Did he recklessly cause the death of another? And then as far as relevance, okay, we have a check next to that. But as to probative value versus prejudicial value, you're going to that aspect of the burden of proof, right?
Right. I'm saying it was relevant, but what was prejudicial and overly prejudicial, because all evidence is prejudicial to some extent, it's overly prejudicial to use that as proof that he intentionally didn't do it in 2011, therefore he did it again. I mean, the limiting instruction said no propensity.
I'm stuck also with your use of the word intent and intentional, because there's no allegation that the defendant intended to kill the people who the car crashed into.
Well, yeah, that wasn't an issue. We didn't think he intentionally killed anybody.
Is there an issue, right, and is there an issue that he intentionally failed to take medicine as opposed to knowing what the consequences were if he didn't take the medicine?
If they had proof that he intentionally didn't take the medicine, that's a much stronger case for criminal recklessness. Without that proof,
You have to prove that he intentionally didn't take the medicine in order to prove.
no, that would have been one way to prove criminally reckless. But in the absence of that, when there's other explanations, such as a combination of drugs, use of generic drugs, maybe he took it and he didn't realize his values were low, those all go to whether he was reckless or not in 2011. The problem here is that...
But I'm still a little confused. In 2011, whether or not he intentionally or didn't intentionally take the drug that day is not really relevant to why it's being introduced in the later case. It's being introduced to show that he knew that if he did not take the medicine, he could get into an accident. That he
I conceded that, Judge.
Right. So, but why was it? why was it being introduced for any other purpose? You keep saying it was being introduced for the purpose of showing that he intentionally didn't take the medicine, but they didn't need to show that to show what its relevant was to the later incident. All they needed to show was that he knew by not taking the medication that there'd be consequences. They didn't need to show that he intentionally didn't take the medication.
But they
That's
went
irrelevant.
further, and they argued that he intentionally did it on both occasions, and therefore that was an overstatement, and it was not factually based. Judge, there's a rule called Grutz that was abandoned when the Court of Appeals decided Rivers in 2011. The idea was that originally you could not usurp the presence of the jury to decide an ultimate issue. And since 2011, under the case People v. Rivers, we now allow partial invasion of the jury's province so long as it's properly relevant. But here you have a situation where the expert went further. Look, we still have rules about expert testimony. It's only admissible when the subject matter is beyond the ken of an ordinary
I'm
juror.
going to let you finish up that argument on rebuttal. Thank you. Do you have a question? I'm sorry.
No, sorry.
Okay, go ahead.
May it please the court, Matthew White for the People.
So did the people have to prove that he intentionally didn't take the medicine?
I think to a certain extent, yes. In this case, we did have to prove that.
And how did you do that?
And we proved that with the testimony of our expert witness, who was a renowned expert in epilepsy medicine and who had reviewed the medical records of the defendant in 2011 following his car crash, and in 2015 following the crash at issue here, and found that the blood test showed that the defendant's epilepsy medicine was at subtherapeutic levels in his bloodstream. And the expert testified that to within a reasonable degree of medical certainty, the only explanation for that was that the defendant did not take his medicine.
But counsel, did the people use the word or words intent, intention, intended?
I think there's perhaps some confusion. Perhaps a better term would be mens rea, because we had to prove recklessness, which
But that says to the 2000, that says to the actual criminal case, not as to the, did you have to prove he intentionally didn't take his medication in the 2011 incident?
I think in this case, to a certain extent, we did, because we had to show that the failure to take that we had to show that defendant knew that his failure to take this medicine could result in an accident like this.
And you're calling that intent?
I'm calling it mens rea. We had to show that the defendant, not only that he should have been aware of this risk, but that he knew the risk and that he consciously disregarded it.
I'm sorry, I guess it's the language, because to me, it sounds like you had to show he woke up that morning and said, hey, I know I'm going to have this accident, but I'm not going to take my medicine today. I don't feel like it. Like, is that what you had to show?
I mean, I think to a certain extent that sort of gets to motive, and we didn't have to prove that. What we had to prove was that he didn't take his medicine, and because he didn't take his medicine in 2011 and was involved in this crash, he was aware of the consequences, and he
What if
consciously...
he didn't take the medicine just because he honestly forgot?
I don't think that matters in a situation like this, where he had epilepsy he was diagnosed with epilepsy with 1978, and he testified that he knew that the consequences of not taking his medicine was dire. And to prove recklessness, we had to show that, again, that he knew the risk of not taking that medicine and consciously disregarded it. And courts have long recognized that this type of Molyneux evidence is admissible to show intent, especially when the intent is not clear from the act itself, and that's the Alvino case. And courts have found admissible evidence, for example, in other cases where a defendant took a driving while intoxicated course and was subsequently involved in a fatal car accident while driving intoxicated. Courts have allowed evidence where a defendant doctor was operating a pill mill and a patient later died of an opioid overdose. And the prior bad acts and crimes in those cases were admissible, even though that evidence was far more prejudicial.
What's the prior bad act?
The prior bad act was not taking his medicine and getting into this one-car accident.
In 2015?
No, in 2011 and in 2015. And the by not taking it in 2011, and again, this is what the expert testified to, the only reason the medicine wouldn't be in his bloodstream was he didn't take it. That's what the expert testified to.
Was there a summons issued?
No, there was no summons issued, and it was a non-criminal accident.
So he wasn't charged in any way?
He was not charged in any way.
Did
and
you use the term prior bad act with the jury?
I don't know if that precise term was used, but it shows that the 2011 act was not unduly prejudicial. It was not a situation where.
Big difference between that, counsel, and calling it a prior bad act.
I mean, I think in general, evidence of some kind of misconduct or malfeasance, we have to make a Molyneux application. It doesn't just come in. We have to show relevance, which is conceded. The only issue is prejudice, and it's conceded. I mean, I don't want to say.
Counsel, I'm sorry.
I'm sorry.
I thought it was clear on this record that both the people and the defense counsel did not view the 2011 evidence or information to be Molyneux. It was coming in to somehow impute knowledge to the defendant in 2015. That's my understanding on this record.
Yes, I think
Fair?
Yes.
So let's assume he had a blameless life up until 2011. He had this crash, and then they took they took his blood levels then, and then they got the values that they got, and then afterward they had a little talk with him and said, you really can't skip your medication because things like this could happen. So now he's on notice.
Yes.
Fair?
Yes.
Doesn't mean it's a bad act. Doesn't mean it's Molyneux. So now fast forward to 2015, where the people have the burden to establish he was reckless. And the expert comes inside and doesn't say he intentionally didn't take his medicine. The expert comes into court and says, oh, look at these values after this 2015 accident. And look at these values after 2011 act. I'm going to draw inferences from that information. The inference I'm drawing is that presumably he didn't take a therapeutic dose to have avoided all this. And that's a factor that you guys wanted the jury to hear, no?
Yes, we had to prove.
So that doesn't mean intentional, that he intentionally didn't take his medicine. The issue is whether he was reckless, correct?
Yes. And I would point out that in terms of the argument that the expert somehow invaded the jury's province, that's totally unpreserved. Totally unpreserved. And with respect to, and with respect to it being a Molyneux issue, that's the way it was framed in defendant's brief. So of course, that's how we responded. And ultimately, at the end of the day, all he had to do was take his pills, but he didn't. And 3 people died as a result. And, okay, thank you, Your Honors.
Briefly on the preservation argument. Defense counsel, before the trial started, during the trial, in summation, continually referred to the people relying on speculation about the cause of the lower drugs in his bloodstream. And that was not an inference that could be made.
I'm sorry, defense
there were
counsel-
other explanations.
counsel-
He said testified
counsel,
at 11 o'clock.
Defense counsel made those references? Did you just say that? Did I mishear you?
Say that again?
Did you say that defense counsel made those references? Or you meant the people?
No, defense counsel argued that there was speculation, that the people were relying on speculation as to why the drugs were low.
Okay.
Was there any motion made before the court to disallow or strike the testimony of Mr. Grant?
Yeah, there was objections to Dr. Grant's testimony. And here's the problem. He not only inferred the cause of the lower drugs in 211, he submitted that, in his opinion, the doctor who wrote the medical record in 2011 also came to that conclusion when the medical records didn't offer that information.
Thank you. Thank you very much.
I guess they saved the best for last. But ours was the most interesting argument of the day.
See you tomorrow. So you're gonna do your, so, well, wait until 9 o'clock, so that way I know everyone is here.
All right, I'm gonna come in at 8 just in case.
Oh, okay.
Emergency.
All right.
Like, I'll wait till 9.
Okay, I mean, I'll know by then anyway, like by 8 or whatever, if anyone's gonna be out.